Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. I'm John Roberti, your host for today's episode, which is Leniency Dead? Long Live Leniency. The Leniency program at the U.S. Department of Justice protects potential criminal defendants if they are the first to identify a cartel. Historically, it has been a wildly successful program where it has helped the government detect cartels. It has led to whistleblowers coming in. It has led to enforcement where enforcement may otherwise not have been possible. There is some belief, and maybe it's true, that leniency applications have decreased. In other words, people are no longer coming in self-reporting to the government in the way they had previously. This podcast will consider some of the reasons why that might be. Ask whether or not that's really true, and then consider why that, if it is true, why that might be. My co-host today is Wendy Waszmer. Wendy is a partner at the Wilson Sonsini law firm. Hi, Wendy.
Hi, John.
So, Wendy, why is this potential decrease in leniency applications important?
Well, as our expert guests will talk about today, the U.S.'s cartel enforcement program is really one of the most well-known criminal enforcement programs in the world. And frankly, taught or raised other type, similar regimes around the world. And there's been a lot of observation that in the past couple of years, the public case volume is not what it used to be. This is a program that generated $1 billion of fines many years. And so I think there's a lot of discussion about whether that is in fact the case, that there's something going on or not. So our experts today will give us some insight in that.
And I imagine we'll also talk about programs outside the U.S. and how that may also be impacting change.
Exactly, because this is an area of the law, criminal cartel enforcement, where there's a lot of coordination, and our guests will talk about that. They knew enforcers around the world, and there's a kind of, I wouldn't say interdependency, but there's definitely linking between these programs. So to the extent the U.S. doesn't appear to be as busy, there are consequences for other countries.
Who are our guests today?
Our guests today, I'm really excited to introduce, are two former prosecutors who were Chief and Assistant Chief Lisa Phelan and Craig Lee, who for a very long time formed a core of the DOJ's Washington Criminal Section, formerly known as the National Criminal Enforcement Section. Lisa is currently an antitrust and cartel partner at Morrison Foerster, and Craig is a partner at cartel and criminal practice partner at Baker McKenzie. And both of them worked for a very long time on some of the biggest kind of international cartel takedowns.
What do we hope to get out of the program today?
So really we're going to talk to Lisa and Craig about what they experienced at the DOJ when they were really inside the program and frankly working on some of the biggest international cases, and what they're observing now in terms of defending clients and understanding what the incentives are and whether companies are still incentivized to come in and get leniency and cooperate or not.
Well, let's bring in our guests. Lisa?
Hey. Hi, John. Hey, Wendy. Great to see you.
Hi, Craig.
Hi, John and Wendy. Great to be here.
Good to see you guys. So let's just start out. I mean, the leniency program for many years really is a carrot and stick type program where companies are incentivized to come in and cooperate and self-report. Lisa, maybe you can give us your perspective. When you were, chief at DOJ Antitrust Division and you saw companies coming in, what did you understand to be the reasons why a company would basically come in and admit to a criminal violation?
Yeah, it seems sort of hard to believe that anyone would come in and tell anyone in law enforcement that they had committed a crime, right? But the incentives that DOJ created at the Antitrust Division were just too good to pass up at the beginning. Here are companies that would potentially be looking at hundreds of millions of dollars in fines and executives going to jail. Instead, if they run into DOJ and say that they were involved in a cartel but point the finger at others, they end up with no prosecution, no fine, and all of their executives are home free. So it really was an amazing offer that was really unmatched in the rest of white-collar crime. But I think we need to talk a little bit about Type A versus Type B. Craig, do you want to tell folks what the difference is between Type A and Type B leniency?
Yeah, absolutely. And I think it's important to know the distinction. For Type A leniency, that's when the company comes in and self-reports a crime that the Antitrust Division had no idea was going on. It completely out of the blue. And Type B is when the Antitrust Division has an investigation or has some inkling of investigation. They just haven't reached that tipping point of being able to form a case. And so I think that the incentives to come in for Type A are similar but different than the incentives to come in for Type B when you know that you might get caught anyway.
Right. So Type B, kind of the cat is already out of the bag. The microscope of the government is down upon you. FBI agents maybe have shown up at people's houses. And so the calculation is different than when you might get away with it if you don't come in for Type A.
And just for those out there who, aren't experts in cartel practice, if you don't come in for Type A and Type B, what are you facing? I think Lisa talked about fines, but what are the consequences when you fail to make the right call or come in at the right time?
So we used to say for first place, you get a complete pass. Second place, you get to plead guilty and pay hundreds of millions of dollars in fines. I mean, the Antitrust Division has brought the biggest fines for any company in the hundreds of millions, and their individuals, the executives, face long jail sentences. There's huge risk.
Yeah. Can I just say, under the Sherman Act, which is the main cartel statute, the maximum fine is $100 million per offense for a cartel offense. But there's an alternative fine statute, which is twice the gain or twice the loss. So there have been many, many fines that have gone up to $500 million for companies. In I think 4 of the last 6 years, the division has brought in over $1 billion in fines. So we're talking big money. We're talking big impact to the economy.
Well, and one other thing that we probably shouldn't overlook is if you are first in, you get to limit your damages in the civil case. It's probably not as big of an incentive, but you're no longer facing treble damages and joint and several liability. So you also get a little bit of help on what will inevitably be the follow-on civil cases.
That's right. That's right.
And you two have, a huge amount of international experience. And what I mean by that is you prosecuted executives who were basically based overseas and companies that were located outside of U.S. borders. Do you guys, now being on the defense side, what are the challenges if you work with companies outside the U.S. versus inside when they're thinking about coming in for leniency?
For foreign companies, I think the big question is not whether the conduct gives rise to a violation, but what's the risk of detection? If they lay low, if they end up, if for the executives, so they don't travel to the United States, if the company just stops the activities, what are the chances that the government in thousands of miles away is going to figure out what the cartel's going on?
And there's some sort of game theory going on when a company thinks about that. So what are the pieces of, information that they have when they're trying to figure out, is someone going to rat me out, or is someone going to discover what the evidence is?
I would think you don't want to finish second. Whatever you do, you don't want to finish second.
That's the tough question you should ask the company is, how would you feel if your competitor beat you to it? Yeah. Would you think that your defenses or your arguments are strong enough, or would you be really upset that you are second now?
But interesting, you also have to think about something you might be doing in the routine course of business could cause the government to detect it. For example, I've seen a lot in recent years, companies are looking to merge with another company, and in the course of submitting their documents to get their merger approved, darn if there isn't the evidence of cartels in there. And next thing you know, the folks have referred it over to the cartel lawyers to criminally prosecute. So you might be not even intending to self-report and sort of accidentally out yourself. So, obviously a large global company is merging and buying companies all the time. So it's a risk they might not even realize they're taking.
So back to the kind of initial point that John raised at the beginning of our conversation about leniency and whether anything has changed and the numbers being down. You guys are insiders. What do you think is going on when we see whether it's fine levels or case numbers, past year or two?
I think that I would be hard pressed to be convinced that Type A leniency is not down. that companies coming in off the street, those applications have not decreased.
Why do you think that is?
Because I think that the costs of leniency are so much higher than they were before. And I also think that there's this general sense that the risk of detection is a lot lower.
Yeah, and I think, especially for a global company, which if they're going to come in, not only do they have to come into the United States, but they may have to come into 10, 12, 15 jurisdictions around the world who also have leniency programs and are also going to want complete and full cooperation over a long period of time. And never mind worrying about state AGs bringing actions, civil damage actions, and they need to realize they're buying themselves 10, 12 years of litigation. And it gets to a point where it's hard to justify.
Craig, I want to go back to something you said. When you say that the cost, that you think the risks of detection are lower, why do you think that? Or that's the perception anyway.
Well, it's one of those self-fulfilling prophecies because they see the statistics are down, that there are less cases being brought, that fine levels, which were well over $1 billion, are now much lower. So there's this perception that enforcement's just on the decrease. So they think that, I think a lot of companies are thinking, well, if we lay low, the chance of us being detected are much lower than they were before.
What do you guys think about like trials? I remember when, we were at DOJ together, I felt like a huge amount of pressure that like the first case out of investigation, we had to win at trial just because I felt there was a deterrence, aspect to it. So there's been a couple of trials, big trials, where the outcome hasn't been great for the DOJ. Do you think that plays into kind of companies' decision at all?
I think for those decisions play more into an individual's decision whether to go to trial or not. I think for a company, it's just still too much risk to go to trial.
Yeah, because you've got, not only do you have the risk of the fine, you have the risk of reputational harm, being in the newspaper every day. And oftentimes a company will, just decide that it's not worth all of that. They'd rather end it quickly and quietly. But I think you're right, Wendy, that some high profile losses happened in the last year or so in some major investigations like auto parts and foreign exchange rates. And, that has to embolden defense counsel a bit to think, we could fight this. We could take this on.
So you guys, have been in this world a long time, and there have been developments in the cartel or antitrust world where there seems to be a greater movement towards overall kind of federal criminal policy, whether that's on enforcement programs or sentencing credit. What do you think is the effect of that if antitrust division is moving in some areas to be closer to whether it's criminal division or U.S. attorney's offices?
I think one immediate impact will be the Antitrust Division has always been reluctant to use deferred prosecution agreements. Mm-hmm. They've always had the policy. We have the leniency policy, so we don't need to use deferred prosecution agreements. That's when a company can avoid prosecution if they adhere to certain obligations, but they also have to pay a fine. And deferred prosecution agreements are used throughout the rest of the Department of Justice. So I think there has been a shift in that mentality for the Antitrust Division to consider deferred prosecution agreements more.
Another change in recent years has been sort of less of a guarantee that all of the executives will be included in the leniency application. And DOJ a couple of years ago said, formers are not presumed to be included. And it's even possible that some current employees could possibly not be included. And that was a huge attraction, I think, to the program for a lot of people, especially because it's often the CEOs that are making the decision whether or not to go in. So they want to make sure they're going to be covered. But under the broader Department of Justice policy that of individual accountability, there was some thought by the division that maybe they should rein that in and maybe leave a few more individuals on the hook. But the problem with that, I think, is it has a deterrent, a discouraging effect on people thinking about the leniency program as a way to guarantee that all the executives, who are often the decision makers, are going to be covered by the leniency. And
it introduces, like you're saying, a level of kind of uncertainty if someone, companies thinking of going in. So in light of that almost changing approach to employees, how do you, if a company's coming to you, Lisa, and says, we really would like to know how this is going to roll out. Like, we're thinking of leniency, we're going to go to the board. How is this going to play out with our employees? How do you counsel that now?
Yeah, it's a little bit challenging. You can't sort of guarantee. I'd say 5 or 6 years ago, you would have said, I feel totally confident that if we go in for leniency, everybody in the company is safe. You can't say that anymore. And you have to be honest that there's more risk now.
And I think you need to explain to the client that this is a marathon, that this will last longer than you want it to last, and you will be responding to requests from not only the DOJ, but from agencies all around the world, and you'll have to make witnesses available, documents available. It's not something that will go away when you want it to. It's going to last for a long time.
Well, and that goes back to both of your kind of points about the cost, basically the cost of cooperation. I think a lot of people who don't practice in this area think, oh, you go in for leniency, you have a meeting, you download some information, and then you're kind of out. So maybe you guys can describe what is cooperation when you're going in for leniency, and how does that, I think Lisa described other countries, but let's just say you're in the United States, you're considering going in. What do you describe to the company about how long that's going to be, how much it's going to cost, and how much investment of their lead executives have to be, is going to have to be put into that process?
I think it depends on the scope of the investigation and the timing. I mean, when I was at the Department of Justice, Lisa and I were there, we had companies come in for leniency, but we remained covert for months, if not longer, in order to do like undercover activity. And there the company has already come in, but months have gone by before anything has gone public. And the company in the meantime is making their employees available, submitting documents, getting wired up, getting consensual phone calls, recorded meetings. And so it's a lot of tasks for them.
Yeah, and you're going to have to do a really extensive internal investigation, because the last thing you want to do is come in for leniency, and you're only going to get leniency for what you bring forward. So you don't want to come in and describe, conduct A and B and never have uncovered C and D, and then down the road after you've brought all this scrutiny upon you, your company, you then end up getting prosecuted for things that you didn't uncover. So it's a big investment to do a very extensive internal investigation to make sure you're turning over all the rocks and bringing everything to the DOJ so that you have the maximum protection.
Right. And Lisa, to pick up on a point you had before, it's really kind of an enforcement feeding frenzy now with not only cartel enforcers worldwide, but whether it's regulators or state AGs or other folks. Maybe just to give the listeners some perspective, when you all started at the Antitrust Division doing cartel prosecution, how many enforcers not only had leniency programs, but were really as active as the U.S.? So if we go back...
Yeah, so since I'm the older one here, I should probably take this in. In the dawn of time, when we...
But before email.
Yeah, before email.
When there were the fax paper
the answer is
conspiracies.
when I started, nobody did, and so the DOJ actually had a sort of moribund early effort that they had made a leniency program that wasn't very certain and wasn't very attractive. So it was really the mid-'90s when they came out with the current iteration that brought the certainty and consistency and transparency to the process that became really attractive. But literally no one else had a leniency program. Some people had slight variations of it in other countries, but DOJ really went around the world sort of encouraging other countries, because the problem was the first leniency applicants came in and they're like, if we hand you evidence, you're then going to turn on and hand it to the EC or to the Japanese Fair Trade Commission, and then then we're cooked over there, and it doesn't make any sense. So DOJ really encouraged other countries to adopt the leniency program so that a company had that option and it wasn't going to be a constraint to them coming forward to DOJ. Now there are dozens and dozens and dozens of countries that have them, and then state AGs kind of saw how valuable and lucrative this enforcement priority was, and they developed their own much more active programs. And of course, back in the day when I started, there wouldn't be civil damage actions filed until after there were convictions at trial. Now, as soon as the first word of the first subpoena going out, those are filed, and sometimes dozens of different cases are filed, and then giant class actions are going on for a decade or more.
And now we see, as you all know, a trend where even individuals are being included in civil class actions while they're under investigation by DOJ, which is, a new trend.
So, but what's changed in terms of cost? So we said cost was one of the things that is driving the difference. What's changed? Is it just that there's more to do? There's deeper internal investigation. There's more undercover work. What's different in terms of the costs?
Yeah, I think it's the number of masters to which a company has to answer. As I said, if you go into multiple jurisdictions for leniency, each one of them wants you to be their top priority in terms of getting the documents, the witness, the evidence that they need, and they all want it happening simultaneously. So you've got to put out a tremendous amount to get all that going. You've got to, and then you're fighting on multiple fronts if the civil class actions are going on. And, courts seem to be increasingly not want to delay. DOJ will often go in and ask the civil court to just wait until we've done the work. And civil courts are increasingly unwilling to do that. So you might be doing depositions and tremendous civil discovery at the same time that you're fighting on the criminal front to make sure you maintain your leniency.
I don't know if this makes a difference as well, but there didn't used to be civil cases outside of the U.S.
That's right. But that's another new trend that in Europe particularly, it's become very common now. It's a really active growing plaintiff's bar in Europe. So now you're also facing those on multiple fronts.
So if you would go in Europe and you were first, you basically got a free pass on everything. You paid no administrative fine and there was really no civil damages. Now you go in and you're first. You get to avoid the administrative fine, but you get the pleasure of litigating against many of the American firms, frankly, that are setting up shop over there.
That's absolutely right. Yeah.
And you're in the position of having admitted to doing it.
That's absolutely right.
So just to get some predictions, I mean, I know we've all experienced this idea that there may be ups and downs. If you have big investigations that go on for 5 or 10 years, you have a breather, and then we go back up and have new matters. Do you guys think this is a downward trend in terms of whether it's leniency applicants or case activity, or do you see this as just a little bit of a lull that could pick up, in the next year or two?
Some of both. I mean, you're right. Resources are really constrained when there's a massive investigation like the auto parts case or the FX case goes through, and because these cases take a while to build. It's sort of natural that there might be a year or two lull. But I think DOJ is also learning that because perhaps leniency has become less attractive at the type A stage, they're starting more preliminary investigations and start poking around, which is going to lead to more type B applications. And I think that's kind of how they're trying to get the next wave going.
Do we need to do anything to fix something to try to get to change the trajectory of the curve? To try if the slope is really downward and it's not, we don't think it's turning around anytime soon. Is there something we need to do? Is that a good idea?
So, I mean, I agree with Lisa. Going back a little bit, I agree with Lisa that I think this is a lull. I think it is temporary, and I think the main reason is because resources were so tied up. I think another investigation that tied up a lot of resources was the real estate investigation. There were several trials going around across the United States that attorneys really want to work on because they like doing the trials, but that took a lot of resources, having to go to trial and prepare for litigation. And I think it just takes a spark. One company comes in, they bring in one conspiracy that begets, there's also Amnesty Plus, which is when another company who's already in investigation tells the Department of Justice about another conspiracy. And that's how the big investigations start, by Amnesty Plus, by other people coming in and confessing to other crimes. And all it takes is one company to do it. As far as what we can do to build that back up, I think it's, I don't know, I can only put my finger on one thing.
I have a thought, to the point I was making where DOJ has sort of in recent years made it less certain that all the executives will be covered under leniency. I think if they would go back to sort of the original model and make sure that everyone was going to be covered, then it's an easier decision for a CEO who might be risking themselves if they open up this can of worms to feel confident that the difficult decision is worth it to still go in for leniency if they're protecting all of the executives.
I mean, that's a good point. I mean, leniency works because there's transparency and there's trust. Mm-hmm. And if you don't have one of those two, it's going to make it
clarity.
harder. And clarity.
Like exactly. A huge amount of clarity, which I think is a little murky now.
Yeah.
So we want to shift gears just a little bit. I'd like to hear from both of you. Why do you like practicing in the area of law you practice in? What's fun?
I love the investigation part, trying to figure out what happened and whether it amounts to a violation. But there's also then the strategic part. If you find this information, what are you going to do about it? Do you self-report? Do you mitigate those risks? And so I love that balance of both the investigation and strategy.
I love that you're just working on huge cases in huge segments of the economy, in cars and electronics and financial services, billions of dollars on the line. And, now in my new role in the defense, I'm helping companies avoid the risks and hopefully never need leniency. And that's exciting. And when I was a prosecutor, holding people accountable and hopefully, making the playing field more fair in the economic landscape was exciting to me.
So, Lisa, why was it that as soon as you left, the DOJ started to prosecute innocent people?
It's so funny. It's like I just keep finding innocent people. It's amazing.
Well, let me ask you a different question, Craig. If you were advising a young lawyer who wanted to get into this space, what would you tell them? What should they do? What should they try to learn?
I think having agency experience is critical. You learn a lot working at the division or another agency, and I think that's very helpful in either whether you want to stay there or you want to work on the private sector. But if you don't have the opportunity, I think it's just getting involved in as many cases as you can. Taking on any role you can in different cases, even if it's the lowest role that no one wants to do, and just kind of building up your experience, building up your expertise.
Lisa, what do you think?
I think you have to have diligence in the antitrust and cartel space, because these cases sometimes are very hard to break or very hard to build, very hard to get your arms around, and you can get discouraged easily. And so you have to have the patience to hang in there and the resilience to bounce back if you get some bad developments, and then you have to have some passion for it. As I said, it's sort of the fact that these are big, exciting, economy impacting cases gave me the passion. And if people can find that, that's the secret to life for me.
Well, let me ask you each this one too. I think our listeners would like to maybe learn a little bit about you that they wouldn't otherwise know. So tell us something that's surprising or unusual about yourself that someone who didn't know you or who only knew you professionally wouldn't know. Craig?
Lisa?
All right. Well, I'll admit to being sort of an overachiever my whole life. So I was especially proud when I was 16 years old. I was, I don't know how many people have heard of Friendly's Ice Cream, but I was Friendly Waitress of the Year. And
for all Friendlies?
For the Western District of Pennsylvania.
Was that like most ice cream scooped, or was it friendliest to the customers?
I think friendliest, yeah. So I'm very proud of that. I still have it on my resume, and I still have my plaque from the Friendly family.
And where is the plaque? Is the plaque?
It's in my bedroom. Yeah, I look at it every day. Not
in your office.
No, not in my office.
Craig, how about you? Did you work at Friendly?
I did not. I've gone there plenty of times. So, probably for me, people don't know is before I went to law school, I used to be a third grade teacher, and so I taught third grade for 2 years, and I always think about that every time I'm in front of the jury. Because in the same way you're trying to take something complex and make it easy to understand, the same way you're taking an antitrust or a violation and making it easy to understand for the jury.
And I have basically a third grade understanding of cartel law. So I
works out perfectly.
Worked out very well today. Well, I think we want to go now to our final segment of the show, which we call the Curious Hat.
And now it's time for the Curious Hat.
So, Craig, we have a series of questions in a hat. We're going to ask you to pick an index card.
Absolutely.
You choose a question, and I'll ask it. And
there you go.
Okay. Question number 16. Do you have any networking tips or particular ways you enjoy keeping in touch with those you've met during your career?
Yes, so my networking tip is anytime you go to an event and you want to leave, you say, I'm not going to leave until I've met 3 more new people. And then you leave. And sometimes one of those 3 new people I met have been great connections and great people.
So my problem is I go to an event and I never want to be there. So what I try to do is I try to make an impression so I can create evidence that I've actually been there. And then I get out of there as quickly as I can. That's because
good, bad, or indifferent.
Yeah, that's pretty much right. That's the problem with being a misanthrope. Lisa, would you like to pick a question?
I would love to.
Okay, and Lisa has picked question number 25. Wow. Oh. Do you currently have any pets?
I do. I have a dog. It's a Shetland sheepdog, and love it.
And now, if you could have any animal, let's say other than a Shetland sheepdog, if you could have any animal as a pet, what would it be and how many would you have?
Well, I don't think you're allowed to have this, but I would have a tiger because I just think they're beautiful.
I believe there may be some code that says you probably couldn't keep it in the backyard.
Especially not in my neighborhood, I don't think.
You would no longer have a sheepdog.
Right, there's that.
Well, that's it for today. Thanks to our guests for coming here, and we will see you next week on our Curious Amalgam.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by the ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent those of their employer or other organization. If you like what you heard and would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. If you have suggestions for topics or are interested in participating in a future episode, please reach out to us at ourcuriousamalgam@americanbar.org. Until next time, thank you for listening.